Hello guys, this is Olayeni Kolola Daniels, popularly known as Dear Spectre, and welcome to another episode of Dear Talks Law. On today's episode, we'll be talking about our first exception on the doctrine of privity of contract. That is what we are talking about today, our first exception. And what's our first exception? The law of agency. Where does it come under? It comes under one of the common law exception to the doctrine of privity. In my first class, I told you that there are exceptions. And I told you, let us learn the general rules. We've learned the general rules. We had 5 classes on the general rules. We talked about the introduction. We talked about the evolution. We talked about doctrine of privity and consideration, part 1 and 2. And then we talked about, the Nigerian cases. In the part 2 of privity of contract and consideration, we talked about the cases, the English cases on it. And now we talked about Nigerian cases. So as at now, we are gurus on the general rule. You understand? But regardless of the fact that we know the general rule, as a sound law student, you should know the general rule and the exceptions. And now we want to talk about those exceptions one after the other. And the first exception that we are talking about is the law of agency, one of the exceptions under the common law to the doctrine of privity of contract. Do you understand that? And before we get into our class itself, if this is your first time of coming to my channel, I want to say a very, very big welcome to you. You are welcome to my channel. Thank you so much for being here. Please make sure that you click the subscribe button, make sure that you click the notification bell, and also make sure that you like this video and share with your friends and colleagues who are going to appreciate the video and in need of this particular lecture video. Also, don't forget to follow me on Instagram and LinkedIn, Dear Kolola Daniels, my LinkedIn account, and Dear_Daniels, my Instagram account. And thank you so much for doing that. So I will go straight to my lecture, and today we are talking about one of the exceptions. Do you understand? So let's go to what the notes say. So on the exceptions, based on the doctrine of equity, exception to the doctrine of privity of contract have been developed over time to relax the harsh effect of the doctrine in most deserving cases. However, there are exceptions created by statutes also. You should know that. Some of the exceptions may appear to be a bit complex because they relate to areas of law which students will come in contact with in subsequent years. Because you are in year 2, you have not done land law, you have not done insurance. Land law is a year 4 course, insurance year 3, year 4, shipping year 5, banking year 5, equity and trust year 4, sales of goods year 3, tort year 3. Now, because you have not done all this, you are still in year 2 where you learn contract, you are learning constitutional law and all those things. I will try to make sure that I teach it to your understanding. I just give you the, rub the head for it and tell you, okay, when it comes to agency, these are things for you to look at. When it comes to covenants that goes on with land, these are things for you to look at. When it comes to insurance, these are things for you to look at. When it comes to trust, these are things for you to look at. So in this lecture, I will not be going in depth like I'll be teaching somebody who is actually doing those courses. Do you understand? But I'll just give you very pertinent things that you need to pass your exam. When you graduate to those levels very soon, by the grace of God, you would get more in-depth knowledge on the subject matter. So our first class for today is law of agency. But before I go to the notes, let me just tell you what agency is. Agency involves 2 people. Are you listening to me? The principal and the agent. Listen to me very well. The principal and the agent. Now imagine I'm in my house and then I employed somebody to work for me in my house. Now, and then I sent that person, God, I need something. Come and buy something for me outside. That person is my agent, or that person is acting on my behalf. Where somebody has been employed to act on my behalf, that person is my agent. Are you listening to me? I want you to understand what I'm saying. When somebody has been employed, my house help or my house whatever, or anybody that I employ to act on my behalf, is who is my agent. Another thing, when the University of Lagos employs lecturers to teach the students, those lecturers are agents of the university. The university cannot teach everybody now, right? I told you that they are a person in law. Universities are persons in law. So the University of Lagos is a person. That's why in some cases, you will see the case of Olaniyan versus University of Lagos. The question is, why is University of Lagos is a person in law? Right? So where University of Lagos, a person employs other people, the University of Lagos is the principal, other people, they are the what? They are the agents. Are you listening to me? So now let us look at what the judge in Golden Construction Company versus STATECO. What did the judge say? Now, Golden Construction Company versus STATECO Nigeria Limited. The Court of Appeal, unanimously allowing the appeal, held that an agency, now I want us to read it in line with this. An agency is a fiduciary relationship in which one party, the agent, now look at that, in which one party, the agent, that is one party, the lecturer, may act on behalf of another party, the university, and that party is known as the principal. Right? Okay. And the lawful act of the former binds the latter. The lawful act of the lecturer binds the university. Where I have a servant and I tell the servant to go and do something for me, the lawful act of that servant binds me, the principal. That is what we call the law of agency. The law of agency is because in the business world, a person cannot be in every place at every time. So the person will usually delegate to other people who will then carry out those duties. So for example, when you are talking about a law firm would have separate lawyers, different lawyers. Those lawyers are the agent of the law firm, so that when those lawyers go to court, the lawyers will say, my lord, appearing before you is Olayeni Diakola Daniels, a counsel at so and so law firm. You can see I am a counsel working for a law firm. That law firm is the principal. I become the agent. Are you listening to me? Do you understand when we talk about law of agency? Law of agency is where you have a principal and you have servants who go out to do lawful duties for the principal, and know that the principal must have mandated that servant to do those lawful duties, either expressly or impliedly or by operation of law. There are three ways by which agency can come about. Expressly, where the principal says go and do this. Impliedly, the principal did not expressly say go and do this, but through the act of the principal, the other parties will do it. And then thirdly, by operation of law. Let me bring it up a little bit for you to understand this thing. Now in your house, if your mother sends you a message to go and do something, when you reach outside and you had say, they'll say this is the daughter of, or this is the son of. So the way they treat you is the way they will treat your mother. Do you understand what I'm saying? So because they know that you are sent by, they accord you with certain respect or certain this or certain that, because they know that you are not here yourself. You are here because of your mother. That is exactly how agency relationship works. Do you understand? When the agent, for example, a UNILAG lecturer is an agent of the school. So when he comes to class and says, I'm a UNILAG lecturer, everybody knows that it is the school that is speaking, not the lecturer. It is the school, the university that is speaking. So if a UNILAG lecturer gives you malpractice form, the university has given you malpractice form because he's an agent of the university. Do you understand? So I just want you to understand the essence of what we are talking about here. So the Court of Appeal unanimously allowed the appeal, held that an agency is a fiduciary relationship in which one party, the agent, may act on behalf of another party, the principal, and the lawful act of the former, that is the agent, binds the latter, that is the principal, in relation to the third party, provided that the acts were done within the scope of authority of the agent and ratified by the principal. Now when you're not talking about scope of authority, you know that when UNILAG lecturers come to teach you, what are their scope of authority? To teach you, what else? To mark your script, what else? To invigilate you, what else? To guide you academically. Those are the scope of authority. Now if the UNILAG lecturer is not telling you to come and meet him in his office, is that part of the scope of authority that the school had given him? Now that question can be answered by stating, what did he come and tell you to come and do in the office? Did he tell you to do something academically, that will still be in the scope of authority. But when it is not something academically and it is going to something else, then can we say that he's acting within the scope of authority, but that is under agency? Can you see that? That's other agency. Let us not start talking about agency. Let us come back home to contract. In contract, when you are talking about the law of agency as an exception to the privity of contract, we are saying that we have the principal and we have the agent. Number one, the principal must have told the agent to act on his behalf expressly, impliedly, or by operation of law. Abi? Also, the agent must have acted within his scope of duty. Abi? And number three, the act of the agent would therefore be binding on the principal. Do you understand that? You can see the case that we are citing, Golden Construction Company versus STATECO, right? Now we move on. In other words, an agent is duly authorized representative of another. Okay, an agency relationship arises by express, implied, and by law, the doctrine of necessity and estoppel. Okay, furthermore, the court held that by doctrine of privity of contract, a contract cannot confer rights or impose obligation arising under it on any person except on the parties to the contract. Therefore, a stranger to a contract is not bound by it, even if it is made for his benefit. It just further enforces what we are talking about. But the essence of citing this case is for you to be able to understand what agency is. Then we'll now look at the application in New Zealand Shipping Co. versus AM Strataweight. In this case, we'll look at the application of agency that we have been talking about. The above highlighted portion of the judgment of the court clearly settles the law that agency relationship create an exception to the doctrine of privity of contract. Now, when we are talking about agency, there are three things. I already told you. Three things. Don't forget. Number one, there must be principal and agents, right? Number two, the principal must have told the agent to act on his behalf expressly, impliedly, or by operation of law. Number three, the agent must have acted within his scope of authority, which is binding on the principal. Have you seen those three things? The agent must have what? Acted in his scope of authority, which is binding on the principal. Number one, they must have been principal, they must have been agents. Number two, the principal must have mandated the agent to act on his behalf expressly, impliedly, or by operation of law. Number three, the agent must have acted within his scope of authority, which is binding on the principal. Now, let us go to our next case to see the application of this rule of agency in the doctrine of privity of contract. New Zealand Shipping Company Limited versus AM Strataweight and Company Limited, also known as the Eurymedons case. Now, what's the fact of the case? The fact of the case is that the appellant were stevedores. I think at this point we already know who stevedores are. Those people that help to remove things from a ship when the ship has arrived at the dock. So the appellant were stevedores engaged as independent contractors to unload the machinery from a ship. So in the first case of Silicon, what they were unloading was a chemical which they mistakenly hit and then negligently and all that. But here is a machinery. The contract between the respondent machinery owners and the carriers, that's the ship, contained a limitation clause. This said that no servant or agent of the carrier will be liable. Look at what the clause says. No servant or agent of the carrier would be liable for any damages unless an action was brought within 1 year. The stevedores negligently damaged the machinery while unloading it. The respondent brought an action outside the 1 year limitation period. The appellant claimed that the clause prevented the respondent from suing them. Now, what was the issue? The issue before the court was whether the stevedores could take the benefit of the time limit specified in the clause in the agreement between the carrier and the owners. Against this, it was argued that Midland Silicon, don't forget, Midland Silicon versus Croutons, a contract between two parties cannot be sued by a third party even though the contract is for the third party's benefit. Now, I want us to understand what is going on here. We have three parties. We have the owner of the machinery, which is being shipped from one place to the other. We have the carrier, that's the ship, right? And then we have the stevedores. The stevedores are the independent contractors who are supposed to offload the machinery from the ship. Now, when there was a contract between the ship owners and the owner of the machinery, and that contract says you cannot sue for any damages after 1 year, right? But the contract said that you cannot sue me, the ship owners, neither can you sue any of my servants or any of my agents. Are you listening to me? You cannot sue me. You cannot sue my servant. You cannot sue my agent. Note that the stevedores, they were not in the contract. There was no part where they said stevedores. They only said you cannot sue me. You cannot sue my servant. You cannot sue my agent. If anything happens to your machine and you do not sue us in 1 year. Now, those people did not sue in 1 year. They sued after 1 year. They sued the stevedores. And then the stevedores now want to argue. But the other party are saying, my lord, they cannot come under this contract because they are not party. My lord, was their name in the contract? Do you still stevedores in the contract? No, there's no stevedores here. So which means they are not privy to this contract and they cannot come under the contract to say that you can't sue us because, you did not come in 1 year. That benefit of it not come in 1 year is only for people that came under this contract and you are not there. Then the stevedores, lawyer for the stevedores said, well, yes, we concede that we are not there, but we are agents. Are you listening to me? We are agents of who? Of the ship carriers. If we are agents, it automatically means that we fall under the contract. Are you listening to me? Can you see that smart exception? The first exception is on agency, right? They are saying that they are agents. They are agents of the ship carriers. And it is in the contract that it would apply to servants and agents. And since we are agents, we fall under the contract. Regardless of the fact that our name is not mentioned, we fall under. Oh my god, that is a very smart thing. The other people brought the Midland Silicon. Don't forget that Midland Silicon was also the stevedores, right? And then we're talking about the United States Carriage of Goods by Sea Act that says that, oh, when you have one particular amount and blah blah blah, and the court held that no, you cannot come under that contract because you were not specifically named in the contract and you not furnish consideration for the contract, right? Since you were not named and you not furnish consideration, you cannot come under that contract. And they wanted to use it for this one too and say, my lord, they were not named, they did not furnish consideration, they cannot reap the 1 year limitation benefits of this contract. But what did the judge say? The Privy Council held that the stevedores could rely on the clause. The bill of lading was initially a contract between the owners and the carriers. The stevedores are not there. It was between who? The owners and the carriers. However, the clauses wording were designed to cover all parties involved in the carriage of the goods, including the stevedores. The respondent obtained the benefit of a directly enforceable action against the stevedores. The stevedores gained the benefit of the time limit. The stevedores has done the work in reliance upon this. Therefore, they had supplied sufficient consideration even though they were only doing what they had already contracted to do with a third party. So you can see the way the judge handled the matter. The judge said, yes, so their name is not in the contract. I agree with you. They did not furnish any consideration to the contract. I agree with you. But the contract stipulates that my consideration would apply to the servant and the agents. What does that mean? So far, I have given you consideration, right? By carrying your goods. Every term of this contract would apply also to servant and agents. It's not going to apply to only me. Do you understand? That's the ship carriers. So the ship carriers included a clause that says that no servant, no agent will be liable. So whatever is a benefit for me as the ship owner who is a party to this contract will be a benefit for my servant and my agent. So as a sound lawyer, when you are drafting up contract for your clients, this is an area that you can also activate. Do you understand? That is why you need to be sound in the area of contract law. You want to be a contract law lawyer. You have to activate this area. If you don't activate it, the privity of contract rule will exclude certain things. So these are areas for you to activate. And this is exception number 1, the law of agency. In my next class, I'll be talking about other exceptions in relation to the doctrine of privity of contract. This first one is law of agency, and I hope that you've understood this class. Thank you for watching to the end of this class. Please do not forget to like and share this video, and also subscribe to my channel. Also follow me on LinkedIn and Instagram at Dear Kolola Daniels for LinkedIn and Dear_Daniels for Instagram. I'll see you in my next class.